Would everybody please stand and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we'll do the roll call. Mark Jakubiak. Chad Impellizzeri.
Here.
Dave Nussdorfer.
Here.
Bob Hawkins. Laura Anderson here. Kristen Graves. Marcia Peterson. Doesn't appear we have public, so I guess that means no public comment. We can move on to item 4, conflict of interest. Is there any conflict of interest with the agenda items tonight? Nope. Okay. Then let's move on to approval of the agenda. I have a question for Bob. Do you have a report from the Planning Commission? We omitted that from the agenda. Okay, then I would like to add report from Planning Commission as item 10 on the agenda and move items 10 and 11 down to 11 and 12. Are there any other changes to the agenda? Nope. Okay. Can I have a motion to approve the agenda as revised?
So move. Second.
Those in favor?
Aye.
Those opposed? Motion passes. Okay, item number 6, approval of the January 29th, 2022 ZBA meeting minutes. Does anybody have corrections?
Should be the 19th, I believe. January 19, isn't it?
Yeah, did I put in I said January 29th, sorry. You are correct.
Where are you? January 19th.
Yes.
That's not right?
That is correct. I stated January 29th instead of 19th.
Oh, over here. Okay, I'm sorry. Okay. I'll move for their adoption.
I actually,
ready
I have a
yet?
correction. I was waiting
All right.
for everybody
All right.
to read. Has everybody had a chance to read through it? Okay. Number 3, public conduct, I think should be public comment. And according to my notes on number 4, Chad seconded the motion for the approval of the agenda, not Mark. Does anybody have a recollection of that? Okay, we'll go with my notes and call it Chad then. Okay. Any other corrections? Then I'll make the motion to approve the January 19th minutes as corrected.
Second.
Those in favor?
Aye.
Opposed? Okay, the January 19th minutes are approved as corrected. Okay, all the routine business having been taken care of, let's move on to what we came here for tonight. As a follow-up to our MAP training session in March, Sarah and Jackie have put together a checklist that we can use as a worksheet during our site visits and bring with us to the hearing as a platform for reviewing the case. I think this will help everybody. help the meetings as well, help everybody think about the things they need to think about before the meeting and ask themselves the appropriate questions while they're on the site visit, and then also provide a platform, some organization to how we proceed through the questions. So I gave everybody the copy with the blue logo on it. And what I did was took my notes. I went back to my notes from the Turek case, and I inserted them so that we could work through this and then talk about how it's used or how we would use it. We're here to make suggestions and make corrections and make it even better if we can. So everybody's input is welcome. And I think as we go through, just interrupt if you have a question or a suggestion. So the top is just the basic information, the applicant's name, parcel number, and I filled that in with the Turek, so you can see. And then the description of request. In his case, it was a rear yard variance. The next section will be consistent on each one that is basically language that is taken from the zoning ordinance and from the Michigan Enabling Act that helps us to stay focused on what our responsibilities are. So let's just read through it, and as we go, if anybody has a question or wants clarification, this would be the time to do it. It is the applicant's responsibility to prove a practical difficulty. It is not the job of the ZBA to find the practical difficulty for the applicant. A non-conforming condition or conditions on neighboring lands may be considered, but will not in and of itself or themselves be grounds for the issuance of a variance. Conditions of approval. In authorizing a variance, the ZBA may, in addition to the specific conditions of approval called for in the Torch Township zoning ordinance, attach thereto such other conditions regarding location, character, landscaping, or treatment reasonably necessary to the furtherance of the intent and spirit of this ordinance and the protection of the public ordinance. So on that last one, I'm curious, Jackie, if we have examples of where the ZBA, I have not seen the ZBA attach conditions, and I was wondering if you're aware of any examples of that?
I can't think of anything right offhand in the last 10 years.
They were all pretty cut and dry. The only thing that this case was different is that we didn't ask for a specific exact variance. That's what I think, that's what I think we need to remember, that if they ask for 10 feet, we give them up to 10. We don't just give them a blank variance, and I mean,
Okay,
this is
So-
done in Ron Turks are fine, their house is great, but in the future, I think we need to be very specific about the amount of variance. Is that right, Mark?
Yes.
okay, and we didn't, he was asking for the full 35-foot variance, and I thought that's what we gave him, but we didn't articulate that during the meeting. Is that what you're saying?
Right. I don't think that was ever clear. I don't know that we gave him a filter. That in a sense we did by not specifying, but I think he was only asking for 2 feet. That could be
No,
the whole 35.
the whole 35, right up to the easement, the road easement. And that's what he got, because that's,
And without going through the meeting minutes and finding all of that, that's why it would be.
okay,
To me,
why it'd be relevant there. But, okay,
2-foot variance. Like a 3-foot variance or 35.
5-foot variance, okay.
This fellow asked though for a 2-foot variance and you gave him 35 feet?
No, he asked,
I misspoke.
he asked for,
Okay.
he asked for a 35-foot variance. Or, he may not expect, in the building plans, it showed him building right up to the road easement, which was in fact a 35-foot variance. But that's good to know that we need to specify the exact number when we do it.
Right. With him, it sounds
Yeah,
like there was only one option, 35 or plus, so that's fine.
Yeah,
But in the future, it's probably gonna just be, you know, what do you need, 2 feet? Okay, 2 feet, and then we stick to it.
okay.
But
Good.
that wasn't the answer, that wasn't your question. No, I don't remember any specifically that there were conditions attached.
So, and the conditions would be included in the motion, or how would you handle that in the meeting?
I would say the idea of finding it back, I mean, you might.
I missed, what was the question again?
So if the zoning board were to add conditions to the variance, would that be part of the motion?
Yes. Certainly.
Okay.
Any conditions we put on it would have to be part of the motion.
Okay. Does anybody have any questions or comments concerning that first section? Then following that is the general finding of facts that Sarah provided in this case. It was in her letter, but we discussed it and we're going to move it to this worksheet because this is what we'll bring, and use when we do our finding of facts. So in this case, Sarah had listed 3 general findings of fact, and so those are the 3 items in blue listed here. And then we move on to evaluating it based on the criteria. So criteria A, do special conditions or circumstances exist which are peculiar to the land, structure, or building involved in which, 1, are not applicable to most other land, structures, or buildings in the same zoning district? 2, show exceptional narrowness, shallowness, or the shape of a specific piece of property on the effective date of the ordinance? 3, show exceptional topographic conditions. Sorry. 4 are extraordinary conditions of land, building, or structures. 5, negatively affect development of property immediately adjacent to the property in question. Or 6, the literal enforcement of the requirements of this ordinance would involve practical difficulties. So that's a lot to think about. And that's the basis for 1 criteria. I have a question on number 2, show exceptional narrowness, shallowness, et cetera. Is that, does that in essence mean the lot is legally non-conforming?
Yeah. I don't believe that you can 100% of it, it's easy to-
Okay. Okay. So I'm also curious on number 5, negatively affect development of property immediately adjacent to the property in question. Can you give an example of that?
Would that have to come in a letter from a neighbor?
I don't know. I'm trying to understand.
Okay.
And keep in mind that the language here is from our zoning ordinance. So it's not like we can change it, but I want to make sure we understand
what it means.
it. And so I'm asking questions where I'm not sure that I completely understand it. I want to have a better understanding.
That was the French drain.
What drain?
The French drain, he wanted to build a structure and put a French drain, and this could possibly negatively affect the adjacent property because of rain drainage water. It didn't, but it could have. Or where they want to place the building,
Pardon?
or where they want, or if some future case they want to place the building. Oh, it was on the bed, I read about it.
What was the last part of your answer there? If the building would have,
Well, what they wanted to build was considered a structure,
okay,
and where they were draining the water had to be specific because of the dune and whatnot.
okay. Then I thought you said it's something to do with the building itself, would negatively,
No, in this case, they were asking for a variance for,
just for the drain.
I don't remember what that was for, you, Mark?
I don't. I think it was the drain.
Like,
So in considering that, they had to make sure that it had to drain on.
I can understand it. I thought you meant the building was maybe, something about the building itself wasn't right.
I
Okay,
know we're gonna leave this room, and I'm gonna be like, that's a great example. But I don't have it right now.
Okay. Any other thoughts or questions?
I guess I'll go with number 4. What extraordinary? I think any appeal would be extraordinary, wouldn't it? Conditions, since I haven't been through too many of these, I don't quite understand. What is an
The
extraordinary?
land can be very uneven, can have elevations to it. And can
Okay.
make it very, very difficult. I recall one we did have on the bay, a high part to it. And it restricted what they could do. Without question.
And they wanted the alternate or change that somehow, or
No,
when you buy a piece of property, you would know that.
correct. You should know that.
You should know that. I think you get very good. So I guess somebody would come then with that type of thing and not know that apparently,
They would have,
and not know the extraordinary conditions of land, buildings, or structure. I just don't quite.
Well, so I guess in this case, the dunes would be extraordinary of the land. It prevented them from building.
Normally, you can't build in dunes, can you? I thought Eagle had that all.
Legal restricts where you can go. And so they tell you where the critical dune is and what to do. They give you the envelope.
Okay,
Then they came to us, tourists, and said, this is our envelope, it doesn't fit zoning, we need a variance. So yes, they did know it ahead of time.
and they knew that Eagle said that, and they still come here. I get it.
They could have read the ordinance and said, you know what, I think we do have practical difficulty, the burden's on me and I can prove it.
Okay,
So what about, back to your question, what about extraordinary conditions of buildings or structures? What would,
Those would probably be your non-conforming or already existing.
okay. Is that clear enough? Okay.
not really, but it just, like I say, I'm not gonna use the whole time I'm new, but I haven't only been through one. If you buy a piece of property and Eagle, for example, says that here's your envelope to build, you know all that. Why would the zoning board of appeals change that when two you've got two entities that say you can't. Am I reading it right?
No, you're not changing where Eagle says you can build. Their example in the Turret case was that they were asking to build into the setback because the building envelope that Eagle gave them was so small. Is that correct?
Yes. And the zoning board determined that they would be deprived of what others enjoy because of that condition, and they shouldn't be penalized in this case.
Okay.
Well, and if, for an example, for like land building or structures, years ago, we came in with the zoning board of appeals because we had a smaller cabin that was his grandmother's that is non-conforming, and at the time, we wanted to put an addition on, and so it was, so right there, we hit criteria number 4 because our building was non-conforming, but everything that we wanted to add onto it was back, it would be in the setback. But we had to come before the zoning board of appeals, and you guys had to, but you did, that you could add. So there are places that may already exist.
That maybe need
people
that.
might want to do something to.
So there should be a comma after land?
Yeah.
Okay.
Yep.
All right.
So then when I went through the finding of facts, I brought down one of them from Sarah. The property is located in a critical dune area and the applicant has obtained their required Eagle permit for construction. I thought that was applicable to criteria 1. So I brought it down from general findings of fact and put it under criteria A. And then in my notes, I also found that I had noted that the Eagle permit severely limited the building envelope on the property. I thought that was applicable and supportive of criteria A.
So may I add a legal question maybe? If Eagle has gives you an envelope and we have the authority here to overturn that there were findings, is what we're saying?
No,
You're changing that envelope?
no, you're not changing the envelope. So in the Turret case, the envelope was small, but it also included area in the setback. And so they wanted to use that area in the setback that was Eagle approved as well.
Oh, in the setback, okay.
Yeah.
Well, okay. But in most cases though, if we can't overturn an Eagle decision.
No,
If
that's,
if there's, okay.
okay, criteria B, would literal interpretation of the provisions of this zoning ordinance deprive the applicant of property rights commonly enjoyed by other properties in the same zoning district? So in my notes, I had an attached garage is or is not commonly enjoyed by other property owners in the same zoning district. Basically a question that I wanted to pose to the board during the meeting because I thought that was relevant. You know, we could say, well, just don't have a garage and your house will fit on the property. So we talked about it in the meeting and decided that it was a commonly enjoyed feature of houses in this area. So that became a finding of fact in support of criteria B. Another question that I had was, is the square footage of the house consistent with other houses in the neighborhood? Is it significantly larger or smaller? And I thought this was relevant because somebody could go in and just want to build a monster mansion on a piece of property and just say, well, you should have brought bigger piece of property, or, you know, this isn't our problem. This is,
Yes.
This is your problem. So that was, I thought that was a relevant question that was in my notes. I would have put it here during the meeting. I asked the question if we knew what the average square footage of houses was in this area, and that information was not available. So it got crossed off. And then I think during the meeting, it was added that there's no ability to move the Eagle approved footprint. And so that was added in red. I kind of changed I color coded here in red. That was added during the meeting as the findings of fact. On C, are the special conditions or circumstances not the result from actions of the applicant, landowner, or predecessor in title? Does anybody have a question about that criteria? It is a little awkward because it's phrased a little awkwardly. I was trying to maintain the integrity of the language from our zoning ordinance and not run into the thing that's happened in a number of meetings I've attended where yes means no and no means yes. So the question, so when we review this, we can say, do they meet this criteria? And they meet the criteria if they were not responsible for something that caused the issue that they're having or any predecessor in title. So then again, the conditions are the result of eagle restrictions due to critical dunes. So we found that, that was in support of, that caused the problem. The owner didn't cause the problem himself. And D, would the authorizing of the variance be consistent with the spirit and purpose of this zoning ordinance and not be of substantial detriment to the neighboring property? And I don't think that we really had any findings of fact that supported or refuted this criteria. Any questions at this point?
But if we remember, we had some pretty overwhelming support from his neighbors. And I would think that if there were any problem owners, they would have raised them. That matters for his application. Am I correct in remembering it?
Yeah, I think you're right. And you're saying that would have been a finding of fact that we could have added under D.
Yes.
Okay. So, and then there's room for additional findings of fact. And here, pulling from my notes again, I had noted that the road easement is 33 feet wide. The road is approximately 12 feet wide. If a variance is approved, the structure will be 10 and a half feet from the edge of the road. And my question, which we discussed during the meeting, was, is this a safety issue?
Like to get a truck down through there or something,
Right,
fire truck or a cement truck or whatever.
right. Is it a safety issue if you need to get an emergency vehicle down there? And so it's just something that occurred to me when I was looking at the property.
That's a good point, yes.
And then under notes and questions, we don't have to go through these in detail, but that's where I would have put the questions that I had that I asked during the hearing. And they were pretty much answered. So so what are our thoughts?
This is good.
Is it something that you think will help on your
I think so.
site visits, that you can work with and come to the meeting with the information, with some information? And I I would basically follow this format then, if this is what we're going to use during the meetings where, once we close the public hearing, I would proceed through and ask for findings of fact in support of each criteria. And then, and just do like a straw poll. Yes, these are our findings of facts, and yes, in fact, they do meet criteria A, and then we'd move on to criteria B and add our findings of fact and decide at that point in time. So we're not jumping back and forth and trying to match things up and remember. And then, once we proceed through all the criteria, then we would do one motion at that point in time where we would either approve or deny the variance request.
So the first page would be filled in for us.
Yes,
So Sarah's comments would be there and
right. And she might include a letter like she did the last time with additional information. But she or Jackie would fill in the basic information at the top as well as their general findings of fact.
To further note too, that I know you know that if even one of these doesn't pass, it's not gonna go. So if you determine in the first sentence, this isn't gonna go, we still need you to work through it, all the findings of fact in case it goes to court. You can't
point.
just stop and say, well, is there a way this is gonna go? If it didn't, you still need to work through all of the A, B, C, and D.
Good point. Thank you, Jackie. Okay, any additional suggestions?
This is a form that we can change at any time. We don't need a planning commission or board approval. It's our working document, so if something comes up, it'll make it easier.
Does this somewhat follow the one they gave us at the training meeting of the
We
the
used,
one in Barber Springs, I think it was?
yeah, we used that as a launch pad, but it didn't really offer room to put, there was a box this big for your notes.
Oh.
And so this was designed to, well, it was, we used that for a launch pad, but this one uses the language from our ordinance. Theirs probably used the language from their ordinance. And then this one was just formatted with space and room so that it could be used as a worksheet when you do your site visit.
Okay.
I like having it all there, Laura. I think it's great.
Thanks. I think it'll make it easier for us to muddle through. So on another note, this is for dimensional variances. There really isn't a set format for the other types of appeals we would hear. I'll work with Sarah and Jackie when those kind of cases come up to make sure we prepare something that helps everybody think through the process. But it would be different. It wouldn't be.
It'd be an interpretation or appeal of a decision.
Right, so then it'd be directing us more towards the language in the ordinance, for example,
That would be probably very helpful. Yeah.
questions on that. So anyway, then we will proceed with using this form. And let's see, then I wanted to ask if there were any other suggestions that people wanted to discuss or had that could help us run our meetings better, or tools that will help us do our job better, things that you might have learned from the seminar, or other ideas you had?
I thought they had, we brought up behavior, kind of the overall what the audience was going to do, their expectations. And it seems like it'd be nice if the screen was down and people saw that. We go into closed meeting, they're not talking, et cetera.
Yeah,
Just a general format, I guess, for
Can-
what's going to happen. I mean,
can we set up the room differently so the screen is down and we can have information up there? Okay, so if we did that, what information would we project? The, what is it called? The rules of procedure for the hearing?
procedures, I guess.
Procedural
yes,
rules for the hearing?
procedural. You know, you'll be called upon to speak. And then when we go into closed session, it sounds like we're leaving the room, but we're not. But that's not a time when we have input from the audience. Just those simple sort of things that you wouldn't have to explain each time when somebody comes in that we're aware of, but they wouldn't be.
Okay, yeah, because there's a list of them that, it's in here that we read. I believe it's in here. Okay, I think page 6 at the bottom. And so we normally, or the chair normally reads the procedures before the hearing starts. Jackie, if we had it up with on the screen, would the chairman still need to read the procedures?
It's probably up to you.
Unless you would just ask them if they had any questions. Those are the procedures we're following tonight. If they're clear. Like you said, unless you want to hear yourself speak.
Not really, but. Okay. Would we put the agenda up there at the beginning of the meeting?
Unless they're getting a handout with what's going on.
I'm gonna wait for signatures.
And I think if you have it posted, then you don't have to.
Hand-
you don't have to get out of the copy. It's just gonna get separate.
Okay.
You might need to consider if people can't see it on the Zoom, you might want to have to read it anyway. You have this in. If the screen is here and the pages are here and here, probably you can pick it up, but we would have to make sure that those people that may not have visual come out.
Okay. And who normally operates the projector?
You just, I guess, depends if you're just gonna put that one thing up for the meeting, turn it up and have it up, switch it out, I can go do that.
Okay. I mean, who around here knows how to operate the projector, I guess is the question.
Yeah, I was gonna say, somebody just plug a computer into it and it was there, so.
Okay.
Yeah, there's a box out there, you look it up, and then you can show it on the screen.
Okay. Well, I like the idea. Does, yeah?
You know, there was nothing wrong with the way the meeting was run. I was impressed with it, but I just thought it gives them a little bit more clarification.
Yeah. Okay. Jackie, let's work to implement that. Okay. Any other suggestions?
Without a their way of looking at it, but you have to change that. You put another notice or another page up. Now you don't have the other one to refer to.
So this is true. I think that we'll need to think through that. My immediate thought would be that, you'd have the agenda up, and then when you are about to begin a hearing, you switch to the rules and procedure of the hearing, and when you're done with the hearing, then you switch back to the agenda.
Yep, that'd work.
Okay, I have one concern about our meetings, and that's when an alternate sits on the board for a meeting, and then the next month, when it comes time for approval of the minutes, they don't have input during the meeting. I don't know if we can have the alternates up here for part of the meeting, and then when we go into hearings, dismiss them. I do understand that whatever we vote, it's only the 5 sitting board members at that moment that are voting on any motion. But kind of wanted everybody's thoughts on that as well. To make sure that if an alternate is sitting in one meeting on the board and then not the next, that they aren't precluded from participating in any corrections to the minutes or clarification of the minutes or anything like that.
Is there any provision in Robert's rules
I'm
that
not
allow them to speak on behalf as because they were there? Or is it possible to swap a member out for that portion?
Well, that's what I'm wondering. And I'm posing the question because it concerns me that somebody who is maybe sitting on the board in one meeting and acting during that meeting then does not participate in reviewing the minutes at the next meeting.
If Jack was gone and Kristen sat in her case, we come back the next month to approve those meeting minutes, Jack would have to, what do you call it?
Abstain?
Abstain because he wasn't here, he couldn't approve that. And then Kristen would be the one to cast that thing out.
But by what mechanism he should do that?
Yeah, that's what I'm wondering.
Well, if someone did not hear the case, they could abstain, and the other 4 members can vote.
Right.
So I don't see an
Well,
issue.
so I sat in on something, but then the next meeting,
Yes.
everyone was here. But, so things that I said, or I wasn't then allowed to make comment if I caught in error in the minutes, even though I participated in that. I think is that kind of clarified? what
Yes,
you're saying?
that's what I'm,
We have not run across that to date, so fortunately.
Right.
I think nobody's just made it an issue, but I think it's happened where,
We have run across it because the meetings where Tureks were here, which was the night that I was on the fire call. I got here late, Kristen sat
No,
in.
right, but he meant, I think, because I did sit in, but I think he meant there wasn't a mistake in the minutes of what I said.
But in the following meeting where I was here, you would not have been able to participate in saying anything about
Correct, correct,
minutes.
correct.
So I asked that.
No, yes, I agree with what you're saying. I think I understood what he was saying as I didn't catch a mistake, but regardless, I think that I personally feel that if I sit up there during the meeting, I would like to be able to look at the minutes and make sure that what I said or what I participated in is correct. Because otherwise someone who isn't here is approving or abstaining from something that they
Mhm.
didn't partake in.
Is there a procedure usually you do for approval, allowing that?
I don't know if we are or not. That's, well, first of all, the first question is, does it concern other people like it concerns me? And the second question is, if it does, then how can we remedy that? Can we have that person participate in some way, at least during the minutes? Or,
Or if you're looking at the order here of the agenda, would. Okay, would I be able to see something during public comment? Or have you already approved the minutes?
You wouldn't do public comment, you're part of the panel.
yeah,
No, I know, I'm saying if there is like some rule that.
can we ask, I mean, can we just, can the chair ask a alternate if they're sitting in the audience the next meeting, but they were up here the meeting before, direct a question to the audience during that approval?
You could have the alternate submit comments, since you should be getting the minutes prior to the meeting. The individual could submit comments to the chairperson that should be read. And because normally, you don't abstain unless you have a comment, if I remember correctly.
Yes.
That in fact, as an individual who's not there listens to the dialogue in the minutes, and normally, if there's consistency in the commentary, then the vote is usually regular vote and affirmation.
Okay,
You normally do not get to abstain unless it's through the time. And I think, the way you might handle it, and I can check with Todd, I think Robert's rules might have something on that. We have rules in our operating policy for the board on that. But as a short-term fix, until we verify that, I could see where submission of correction to the chair, that the chair would then read to the board, the sitting board, and let them decide if the commentary is correct. That's just a suggestion.
okay,
Like a simple way.
yeah,
We're not trying to change the rules and all that.
okay. All right. Any other thoughts? Great, then let's move on to zoning administrator's report. Jackie, do you have any?
Well, I think if the weather really warm, it's definitely been picking up. Calls and picking up inquiries and that. Very slow winter.
Yes.
Where's
has
it been getting warmer?
It says.
I have snow every morning.
So at this point, is there anything, will there be anything?
What Bob's about to say is, I'm sure we have the same information, so I want Bob,
Okay,
your business report, if you want.
Well, yes, step on yours, Mark. We got on March 8th, we had some correspondence from Lincoln County notifying us, the planning commission, of their intent to plan on their master plan, modifying the scope of their master plan. We discussed high water mark amendment as a means of trying to establish a common and non-changing reference point for establishing setbacks. that is still going to be an ongoing discussion. We talked about some strategic priorities for the 2022 master plan review. Sarah gave us some really notes for us. We talked about the annual report, the planning commission annual report. It's going to be reviewed quick. We talked about zoning amendment approval criteria. And that's going to be an ongoing discussion for next month's meeting.
Zoning amendment? Is that what you said?
Zoning amendment approval criteria, similar to what we talked about here tonight. There were several members with public comment. We adjourned at 8:42, and by the way, we have 2 meetings next month. We have one on the 10th and one on
Just to elaborate on what those are, you know, the-
Yeah,
May 10th, we'll hear 31 Stoops' special use permit application for adding non-motorized water toys to their services. And we will hear from the Torchport Airport that wants to do more of a camping breakfast plan, camping fire trucks, weekend, similar to what they did last year. Then on the 11th, we hear the Dollar General. We figured that they would need the time and the space to have their own agenda.
The only other item that might be put on there would be high water line discussion, plan for addressing, and keeps getting kicked down the road.
so that would be on the 11th or the 10th or wherever.
Probably
Those applications will be on the website, it will be prior to the meeting date here to consider.
Okay,
Or here.
okay. Great. It is getting busier, huh? So, but that being said, we probably or definitely won't have anything in May. It would have had to have been in by now, right?
Certainly, if not today, but tomorrow or whatever, then there's nothing.
Okay, then I think we'll plan on canceling the May meeting.
I have a question, and I don't know whether it belongs here or the planning commission or the whole commission. But in the, our rules of zoning ordinance, is there a place in there for, I'm gonna call it common sense, but nobody knows what that means, except me. About if something's gonna happen, and of course, it could be a number of things. Right now, we have several things that are not very popular, but it could be more down the future, a marijuana store or whatever. Is there anything when the public outcry is loud enough, and I don't, or big enough, whatever that adjective should be, that they don't want this, even though it meets all the rules that somebody wrote down somewhere? Does that enter in anywhere in the process?
Well, my understanding is that, if they meet all the rules, or we have to approve what they're asking for. If they cross their Ts and dot their Is and it's consistent with our ordinance, then we have no basis to deny them. I guess the next step would be, the public outcry would be to hold a referendum, get up a petition and have a referendum. Is that correct? So.
It is subjected to planning commissioner's evaluation of does it meet the master plan?
To whose discretion? The planning?
Planning commission.
Okay, not this group, but the planning commission.
Right.
So I should probably go to the planning commission and pose that same question. And I'm not going to,
Well, there's two things. One is there's public comment. So when
Yeah.
if you're talking about addressing a specific issue, not a generalized commentary on the operation, whatever commission it is.
no, I don't have one specific thing right now,
That's
but it,
what I'm saying is that if there's a specific item, that's where you would voice it
in that one spot, there's some flexibility in the,
And basically, public comment is public comment, as long as it pertains to, you don't want to go to the planning commission complaining about the village.
but if there, and maybe this isn't the forum for this question, but if you have a public outcry and we have a set of rules and they meet all the rules, but the public outcry is no. Or yes, it could be maybe the other way around. Does that enter in at all in the thing?
Planning commission is an independent group, and they have to make the decision as they see fit. And then whatever that decision is whether these are as options. And it proceeds from that. And that fit in with the master plan or not fit in with the master plan would be one way the planning commission would have it. Assuming, because there's criteria that you would go through, much like you would on one of these decisions, and some of them might be straightforward, some might not be, but when you talk about whether it's just, this doesn't fit with the spirit of the community, consistent with the master plan.
Exactly.
That would be something where the planning commission could take that into account and make a decision. But then ultimately, the referendum, that's the ultimate.
I just see a lot of problems coming down the pike.
I have about 80 letters right now from the public regarding Dollar General.
Well, I know that that's a big one, but you know, the ice scoops, but there's just so many more that could have come in. And I'm thinking of how some communities can regain or keep the charm and what really makes that community before a big box comes in. I guess they call them poison pills. Like, you know, some cities have banned McDonald's with the big archers and all that. You know, I'm just afraid to I don't want to see this community destroyed by a bunch of commercial.
Well, let's bring that to ZBA.
Pardon?
It's not the ZBA.
Yeah, I know. I'll have to voice it. I have my opinions, and
Do come on May 10th.
I plan on that. Yes.
All right.
Sorry to deviate.
No, that's okay. I think it's of interest to everybody, and this is a casual meeting where we're just trying to, all get on the same page and know what we're doing. So, any public comment? In that case,
I have one more question.
okay, go ahead.
If I have a question on this sheet, who would I talk to?
Me.
Okay, I'll talk to you. I'm the Lee Scott on the short-term rental. What I've got here, what was the outcome of that?
The outcome is that I spoke with the person who is responsible for the verbiage in the ad for the VRBO. It's a place called Golden Swan Management. And it was a stock thing that they put in there. So they changed it so that it doesn't allude to the fact that you can rent for less than 30 days. The beginning of the ad said no rentals under 30 days, and then in the middle of the ad it said if you rent for more than 14 days, you'll be assessed a housekeeping fee. So it wasn't consistent. It kind of alluded to the fact that that would be available for less than a 30-day rental, and it's not. So that verbiage was all changed. It is specifically for a 30-day rental, which it is rented for 30 days.
Thank you. I'm sure it was cheap too.
Pardon?
$200,000.
Yeah, I was gonna say, I sure it was cheap.
What?
200,000 a month. Yes, I heard it was an astronomical figure.
It's horses by the day, horse shows by the day, people that rent you.
It's a different league from what I've been. I'll tell you that.
They want to take it to Florida in the middle of July.
And rent your place for 30 days, so I'm gonna be there for.
Oh,
They rented a house in Milton for 50 for the veterinarian, for 50,000 for the
Oh,
Wow.
it's the big time, I guess. Thank you. Okay, I'm done.
All right. So are we ready for a motion to adjourn?
Also move.
I'll second.
Okay. All those in favor?
Aye.
Those opposed? Motion carried.
So maybe we'll see each other in June then, or we don't know yet.
We'll have to hear from Jackie whether we've got a case, so.
What's the smile for?